I'm here to discuss an issue concerning many boards who manage new construction or gut rehabilitated condominiums, which have severe construction defect problems. And in addition, the boards are faced with sponsors that have limited financial resources and individual unit owners who are being harmed by the current economy. We have several condominium clients where there have been major construction problems leading to leaks, leading to failures of major mechanical systems, problems which interfere with the everyday life of their unit owners. They have really only two options. One is to deal with the problems, and one is to ignore them and hope someday when the economy gets better, the sponsors who built the buildings might come back and fix them. It's our view that the board members are fiduciaries. They have a responsibility to address the problems now, and I'm going to discuss the best ways that we think these problems can be tackled. As you know, condominium boards really have only two sources of funds. They can assess their unit owners, and if they've been in existence for a while, they may be able to borrow funds in order to do these repairs. But the responsibility, ultimately, for correcting the defects should be borne by the sponsor, not by the board and not by the unit owners. So we work with boards to devise an effective plan of attack against the sponsor. And what we recommend is that the boards follow two paths. Generally, we recommend they follow them at the same time. The first path is to file a complaint with the New York State Attorney General. The AG, for short, is the organization that is responsible for reviewing offering plans and for responding to complaints concerning a sponsor's failure to live up to its obligations under those plans. That's step one, filing a complaint with the Attorney General. Step two, in most buildings, when you see a construction defect, it's related to a warranty or other promise contained in the offering plan. So there are often time periods in that offering plan within which a board must act in order to preserve the rights of the unit owners. A notice of all defects needs to be given to the sponsor, and the board seriously must consider filing a suit to avoid the passage of a contractual limitation period or a statutory limitation period. In both cases, the board has to prepare in order to be credible when it either makes a claim or files a suit. And the correct way to prepare and to be able to assert a credible claim is to hire a professional engineer or architectural firm to go through the building, to document the problems, to estimate the costs to correct those problems, and then to issue a report, which can be given to not only the sponsor, but the Attorney General, and be the basis for a set of plans and specifications to be used to either cure the defects, or certainly it can be used as the basis for claim in a lawsuit that may be later filed. The Attorney General has limited resources. Often the Attorney General will use its engineers and its assistant Attorney Generals in enforcement to review the merits of the claim that a board will file. But sometimes the AG is overwhelmed, and so the condo board has to be ready to act on its own. By filing a complaint, it can certainly do that. The sponsors are subject to severe sanctions if the Attorney General does choose to move forward. The enforcement power of the AG not only can include imposing fines, probably forcing the sponsor to correct defects that it promised to correct in the offering plan. For example, if a building is supposed to be built to code and it's not, the AG can require a sponsor who has not clearly identified the defects in its plan to come back and to remedy the problem. The strongest club that the AG has in its arsenal is the obtaining of an order which bars the sponsor from engaging in real estate development in New York State. That's a very effective tool, and sponsors who are not one-shot deals by coming to New York and building one project and leaving, but instead plan to be here and plan to continue to do real estate projects, don't want to be subject to such an enforcement proceeding. What we try to tell boards is that you are fiduciaries. You've got to protect the value of the building. You can't let a defective situation sit and get worse, because you run the risk of other financial problems visiting the board and hurting other unit owners. Individuals who are subject to constant leaks might stop paying their common charges. Others might file complaints with the Departments of Buildings or Housing Preservation and Development. These complaints can come back to really harm the development because fines and orders to correct might result from those filed complaints. So we work with the board to try to be effective. We try to get the Attorney General, which we think is the strongest club and the one of least cost to the condo, to get involved. If we can't, then we work with the board to prosecute a lawsuit diligently, working with the engineers to make sure the facts are fully documented so that the condo board has the best chance of success. Hopefully, everybody who's on a board will understand his or her responsibility and be able to implement these procedures so that a building that is suffering from defects can find a cure. Thank you.